Good morning and welcome to our panel discussion this morning that's provocatively titled Dr. Strangelaw, or How I Learned to Stop Worrying and Love States' Rights, sponsored by the class of 1977. This is as loud as it gets. Wait a minute. Is that better? Hello? Like this?
No, the mic's not on.
Yeah, that's what I'm thinking. They're on? Okay. All right. Can you hear me now? Okay. I'm gonna have to engage in some contortionism here. Oh, like this. How is this? Better. Good. We're trending well. I just want to quickly introduce the panel. Arrayed on this stage up here before you is an assemblage of some of the finest legal thinkers anywhere, and I'm up here too. The moderator originally intended for this panel, who's an absolutely brilliant law school professor and also a member of the class of 77, was ultimately unable to participate. So for no apparent reason, I was asked to moderate instead. And let me just assure you, if any one of you had tossed a chair out your office window, you could have hit someone at random better qualified for this job than I. Let me introduce our panel. I'm going to do this in alphabetical order first. Harlan Levy is a partner at the law firm of Boies Schiller Flexner, LLP. He is a preeminent lawyer in New York for governmental investigations and litigation, business litigation, and white-collar criminal defense. Called one of the best legal minds in the state by New York Attorney General Eric Schneiderman. He's Amherst class of 1977, by the way. Harlan has been described as a lawyer of, quote, patience, integrity, and judgment by the New York Law Journal. He served as Chief Deputy Attorney General of the state of New York, the second highest ranking official in that office from 2011 to 15. He played a critical role in overseeing a number of significant investigations by that office, and they resulted in several multi-billion-dollar settlements. Mr. Levy is President-elect of the Federal Bar Council and of Court and the former chair of the Council on Criminal Justice of the New York City Bar Association. He received the 2016 John J. McCloy, who happens to be Amherst class of 2016. There's a pattern developing here. The McCloy Award from the Fund for Modern Courts and the 2016 Public Service Award from Citizens Union. After graduating from Amherst in 1977 and then from Columbia Law School, Mr. Levy served as a prosecutor in the office of Manhattan District Attorney Robert Morgenthau, class of 1941. This is what you call a leitmotif. An early national leader in the use of DNA to free the innocent and convict the guilty, he authored And the Blood Cried Out, which is a wonderful book. Very popular book on the use of DNA evidence in the courtroom, reviewed as superb by the Wall Street Journal and as riveting by Publishers Weekly. But Mr. Levy's greatest accomplishments are seated right over there. His magnificent 12-year-old children, Caitlin and Gavin, and they're sitting with their wonderful mother, Justice. I guess I should have done the math. Amherst class 2000, whatever. Just have kept it rolling. And they're sitting with their wonderful mother, Justice Kelly O'Neill Levy of the Supreme Court First Judicial District in New York. And that's Harlan Levy. Next, Dr. Austin D. Sarat is the William Nelson Cromwell Professor of Jurisprudence and Political Science and the Associate Dean of the faculty here at Amherst College. He has written, co-written, or edited more than 50 books in the fields of law and political science. Professor Sarat received a BA from Providence College, an MA and PhD from the University of Wisconsin-Madison, and a JD from the Yale Law School. In 2008, Providence College conferred an honorary degree of laws upon Professor Sarat for being, quote, an internationally renowned scholar of capital punishment and for his pioneering work in the development of legal study in the liberal arts. He's also received an honorary degree, of course, from Amherst. While Professor Sarat's primary research focus is the use of the death penalty, his pedagogical interests are wide-ranging. His popular Amherst seminar titled Murder has been profiled in the New York Times. He's also an enthusiastic teacher of first-year students, regularly offering an introduction to law, jurisprudence, and social thought, and a first-year seminar titled Secrets and Lies. He also co-teaches a course on law and film. Professor Sarat's description of his teaching seems the very distillate of the Amherst experience. He writes, quote, these courses, like almost everything I teach, are deeply interdisciplinary, moving out from the study of law or political science to draw on philosophy, literature, sociology, and history. My hope is to take students on a journey from the familiar to the strange. That is, to start with something about which my students are familiar and using the insights of different disciplines to illuminate the complexity of those familiar subjects." Close quote. And that's why we all came to Amherst in a nutshell. Professor Sarat has won numerous awards and recognitions for his writing, his scholarship, his teaching, and his mentoring. And just by happenstance, one of my offspring, Amherst class of 2006, fondly remembers Professor Sarat, quote, "running all over the Red Room," and that he was an excellent advisor who, quote, "really cares about his students." And that's Professor Sarat.
No more running anymore.
Well, we're all disappointed to hear that. And last, but certainly not least, Paul M. Smith, Amherst class of 1976, is Vice President of Litigation and Strategy at the Campaign Legal Center in Washington, D.C. Mr. Smith joined CLC in January 2017, where he works directly with its talented team of litigators to protect and improve our democracy through innovative litigation strategies. Paul has more than 3 decades of experience litigating a wide range of cases. He has argued before the U.S. Supreme Court 19 times and secured numerous victories, including in important cases advancing civil liberties. 2 examples are Lawrence versus Texas, the landmark gay rights case, and Brown versus Entertainment Merchants Association, which established First Amendment rights for those who produce and sell video games. In addition, Mr. Smith has argued a number of important voting rights cases at the Supreme Court, including those involving issues of partisan gerrymandering, the legality of Texas's mid-decade redrawing of Congress. He sort of has made a cottage industry about kicking around my state, if you'll notice in here. And the constitutionality of a voter identification law. He's also served as counsel for interested parties who filed in several key campaign finance cases. Mr. Smith has been honored nationally by a variety of publications and organizations, named Chambers USA as one of the country's leading lawyers in appellate litigation, media and entertainment law, and First Amendment litigation for multiple years. Washingtonian magazine recognized him as one of Washington's top lawyers. He also has received from the ABA the Thurgood Marshall Award from their section of individual rights and responsibilities for his work promoting civil legal rights and civil liberties. Mr. Smith previously served as a partner at the law firm of Jenner and Block. In addition to his work at CLC, I don't know where he gets time for this, he also teaches as a distinguished visitor from practice at Georgetown University Law Center. Mr. Smith is a member and former chair of the National Board of Directors of the American Constitution Society and a former board member and co-chair of Lambda Legal. He has been a tireless and dedicated volunteer on behalf of Amherst and currently serves on the Amherst College Board of Trustees. A truly remarkable group. So thank you all very much for being here. Let's start off just by providing everyone with kind of a base level of information about the topic, and what we're going to be talking about today is states' rights. And what I'd like to ask is for Paul to give us all just kind of a summary of what we have meant in the past by that term, states' rights, and how that term has changed.
Well, I guess why the title of this thing is Learning to Love States' Rights, Dr. Strangelaw, whatever it is because the term states' rights has a long and rather sinister history going back to the pre-Civil War era, when it was invoked primarily by southern states trying to resist any effort to eliminate slavery, and it was associated with the nullification doctrine, the doctrine that states had the power to decide what was constitutional and what wasn't, and could essentially basically plot their own course. One would have thought a lot of that extreme version of states' rights was ended at the time of the Civil War, the passage of the post-Civil War amendments, but it made a kind of reappearance, a little cameo reappearance in the 50s and 60s after the Brown versus Board of Education case in the era of massive resistance to school integration. But I think it's important to sort of step back and say the concept of federalism and the idea that states have rights is nothing controversial about it in another sense. It's sort of built into the structure of the Constitution that the federal government has limited powers and the states have all the residual powers. And in more recent times, it's been the Supreme Court itself that has been pushing federalism, protecting federalism, and using it in a lot of cases to push back against efforts at the national level to promote civil rights and other important federal policies. For example, most recently, perhaps the big Affordable Care Act case was all about whether or not the federal government was invading the province of the states both by imposing the mandate, the health insurance mandate, and then also by forcing states to expand their Medicaid programs. And so this is a constant and recurring theme in American history, in part of our basic governmental structure. And I think what we're talking about here today is that for most of our history, most of the time, I think people trying to push a more progressive agenda have viewed states as kind of an unfortunate barrier, and the whole idea of federalism is a problem. At least in most of the time in recent decades, it's been at the federal level, both the Congress, the President, the Supreme Court, that people have been trying to achieve these more progressive agendas, and the idea that states retain residual authority has been viewed as a problem. And so in some ways what we have now is a reversal, and that's what we're here to talk about. In the era of Trump, where we have an administration and a Congress that's not exactly pushing universal health care, not exactly pushing civil rights, civil liberties, and environmental causes, a lot of other things. Suddenly states are being rediscovered by those of us who in the past have probably viewed them as more of an inconvenience than anything else. And so I hope that's a good introduction of where we're going.
It's a fabulous introduction. Harlan, can you build on that and give some examples of states advancing this new version of states' rights?
Yes, I'm happy to, but I'm going to take just one moment to introduce our moderator, because Frank Stevenson is no slouch. Let me tell you.
Despite his apparent modesty, I don't know.
Frank is currently the president of the Texas Bar Association, is the former president of the Dallas Bar Association, and is just he's a very distinguished lawyer in a major firm, Lock Lord, and he's a wonderful person. So I'm going to, if you don't mind my indulging myself, Frank. I'm going to talk about three watershed moments from the last decade involving litigation by the states against the federal government. As Frank mentioned, I was formerly in the New York AG's office. People in AG's offices right now, particularly Democratic AGs, sense both enormous pressure on themselves because they're viewed as a central part of what is referred to by some people as the resistance. So enormous pressure and also enormous opportunity. And when we talk about those three watersheds, there are really three key moments, and one of them started almost exactly a decade ago, 10 years ago in April, when the Supreme Court ruled in a case called Massachusetts versus EPA. And at that point, George W. Bush was president, and there had been petitions made by environmental organizations to the Environmental Protection Administration asking the EPA to make rules. It's called a rulemaking process, but to essentially extend itself to conduct a close examination of the risks of carbon dioxide emissions for global warming and determine if there was a risk, and if there was a risk, to promulgate rules. And the EPA had declined to do that, and Massachusetts and a number of other states took the EPA to court, and the Supreme Court ruled in one of those kind of classic 5-4 decisions that we're all getting so used to in this country and that are maybe sadly now going to be a thing of the past, but in one of those decisions ruled that the EPA had to engage in rulemaking and had to address global warming in that context. And this wasn't some whim of the United States Supreme Court, nor some whim of Massachusetts. What Massachusetts said was, look at the Clean Air Act. And under the Clean Air Act, given the evidence that is presented, the EPA has to engage in rulemaking, and the Supreme Court agreed. And that was really the first case recognizing at the highest level of the Supreme Court the potential for state litigation against the federal government of this nature. The pendulum then shifted. President Obama was elected, and Frank kept returning to Amherst, Frank, and I'll return to Texas for a moment. The Attorney General of Texas, then Greg Abbott, who's now the governor of Texas, used to describe as Attorney General of that state as being, I go to work, I sue the federal government, and I go home. And during that time doing that, he sued the federal government at least 48 different times. And a lot of the state attorney generals, from the people who were the most aggressive, like Ken Cuccinelli in Virginia, to the ones who were more moderate. The West Virginia AG was very, very active around global warming issues. They kept suing the federal government under the Obama administration. There's nothing new about that. But when I talk about the three watershed moments, the most important moment, the one that is most upsetting to those of us who view global warming as an existential threat to the planet and to our children, was the litigation against the Clean Power Plan brought by Texas. The Clean Power Plan was the most significant administration of the Obama administration when it came to global warming. It was the plan that was designed to address the Paris Accords. The argument that the Republican attorney generals made was that the plan exceeded statutory authority. And that's a recurring theme throughout those litigations brought by the Republican attorney generals. They would say, look at the statute, look at what the administrative agency has done. The administrative agency has gone too far and was not authorized to do what it did. And the case was in the DC Circuit Court of Appeals. The Supreme Court decided to stay. They went to the US Supreme Court, the Republican AGs, and the Supreme Court stayed the implementation of the Clean Power Plan until the DC Circuit could rule. In the meantime, a new president was elected, and last month in April, the Supreme Court again stayed litigation against the Clean Power Plan while the new administration rewrites the plan. So a very significant decision on a case brought by Republican AGs. The third threshold moment is the Trump administration's executive order, styled as an executive order to prevent terrorist entry into the United States. There were cases brought by the Attorney General of Washington State in the first instance, which succeeded. And then when the Trump administration issued a revised executive order, there was a litigation brought by the Attorney General of Hawaii, Doug Chen. Both succeeded. And the thing that was most fascinating about both of those litigations was the extensive colloquy in the district courts and also in the appellate courts about whether it was legitimate for the courts to consider not just the statements made by President Trump, but to also consider the statements that had been made by candidate Trump. And both the district courts, both that considering the original travel ban and that considering the revised travel ban, said that it was appropriate to consider the statements made by candidate Trump as part of their conclusion that this was, in essence, a Muslim ban and was therefore unconstitutional as an establishment of religion under the First Amendment. I will point out to you that this week, the federal appellate court, considering the litigation against the revised travel ban, affirmed the decision of the trial court, saying that the revised order, the one that was the new and improved order, quote, drips with religious intolerance, animus, and discrimination. Finally, before closing, just because we're in this great hall of a great academic institution, I will note for you the role that universities played in these decisions, because the way that both the Washington AG and the Hawaii AG teed this up as a matter that was appropriate for the states to address was by making concrete, detailed showings about how the travel ban was going to adversely affect state educational institutions by impinging on students who needed to attend those schools and on faculty who were needed to teach at those schools.
May I just file a little bit of an amendment to some of what's been said? Please. So how many of you in this room majored in political science at Amherst? How many of you knew Earl Latham at Amherst? So why didn't more of you major in political science? And did Earl Latham have anything to do with your decision? So when I arrived, Earl Latham was a legendary figure on the Amherst campus, and really a very significant figure both in American political science and in the world of American politics. And Earl never missed a moment in which he could remind you of his status in the world beyond Amherst. He was a generous intellect and a very witty man. And you didn't cross Earl Latham. Earl famously described one of his colleagues as having the personality of an empty gym locker. You didn't cross Earl Latham. Early in my career, I did cross Earl Latham. And I crossed him, oddly enough, over the issue of federalism. When I arrived in the early 1970s, just really after the end of the high point of the Warren Court, there was a lot of concern now that the Supreme Court would not defend a set of values which we might call values of equality and inclusion. And I was one of those people who was worried about this moment in American politics. And I remember having a conversation with Earl Latham in which I was bemoaning this turn to the right in the Supreme Court. And this was right around the time that Justice Brennan was speaking out in the 1970s on behalf of states' rights. Justice Brennan, who himself was worried about this turn in the jurisprudence of the Supreme Court, was urging state Supreme Courts to go their own way. And in fact, I don't know if we'd say this was nullification, Brennan urged Supreme Courts to ignore Supreme Court decisions which they found, quote unquote, unconvincing. In any case, to end my Earl Latham story, I was bemoaning this idea that progressives would have to rely on state and state governments, and Latham said to me, "Do you remember Lochner?" I'll pause just to give those of you that went to law school a chance to remember Lochner. Lochner versus New York, I think maybe the most famous case in constitutional law.
That's
Early ones.
Let's have a vote.
I don't know.
In any case, as I was saying, Lochner, the most famous case in constitutional law, was a case in which the United States Supreme Court struck down progressive legislation at the state level.
That's true.
And what Paul referenced, I think, is absolutely right. When we hear the word states' rights, people who are of a certain generation think about John C. Calhoun and George Wallace. But there is a lot in between John C. Calhoun and George Wallace. And what is in between John C. Calhoun and George Wallace is a long tradition of states going their own way in a more progressive direction. Massachusetts abolishing slavery in 1783. Wyoming giving women the right to vote in 1869. And in the progressive period, in New York and Oregon and elsewhere, state legislators pushing beyond what the federal government was doing in the way of expanding what I would call an equality and inclusion agenda. And Earl Latham, in a very subtle way, reminded me of that as I was bemoaning the turn in the 1970s of some progressives back to the states.
Excellent. Paul, talk a little bit about how state courts and state constitutions are also advancing this states' rights.
Well, I guess what I would do is build on what Austin was just talking about. A lot of the progressive work that was done in states in between John C. Calhoun and George Wallace has actually continued is done by state courts, some of it by state legislatures, but some of it by state courts. And there's a particular way in which the state courts have been very valuable at getting ultimately a national resolution of controversial issues and getting to a place where the country would never have gotten otherwise. And the example I would give is the progress toward LGBT equality that has occurred in this country rather remarkably over the past couple of generations. And the way that was won was to use state courts and state constitutions to go step by step to win victories in each individual state. There was an effort to win an important victory early on in a case called Bowers versus Hardwick back in 1986. They went straight to the Supreme Court and said no state should be able to criminalize gay sexual intimacy. And they lost rather spectacularly 5-4 and set back the movement for equality by at least 20 years, having lost because they hadn't laid the foundation yet for that kind of victory. But then for the next 17 years, the movement went state by state and said, under your state constitution, this can't be right, that you can go into somebody's bedroom and arrest them for what they choose to do with another adult. And they won victories in all sorts of rather remarkable conservative places like Arkansas, Tennessee, Kentucky, Montana, Georgia. And so 17 years later, there were only a relatively small number of states that still purported to have the power to put people in jail for that, and the Supreme Court overruled Bowers versus Hardwick, found a national consensus that there ought to be some protection for that kind of behavior in a case called Lawrence versus Texas. The same thing then happens in marriage equality. If you had gone to the Supreme Court in 2000, 2002, 2003, as some people wanted to do, and said you should have a right to same-sex marriage equality, you would have lost. The country wasn't ready for it. The Supreme Court wasn't ready for it. And how did the country get ready for it? Well, a lot of different things happened, but probably the most important thing that happened was somebody brought the right case in Massachusetts. The Goodrich case in 2003 made Massachusetts the first state in which same-sex couples could have full marriage equality. And so by 2004, you had images on television of people getting married, and people learned very quickly that this didn't really change anything for anybody except for the people who were affected by it, who were going to be much more secure and safe and happy. That it simply increased the sum total of happiness in the society. And why are we so upset about it? Now, I wouldn't say that lesson was learned immediately. There was a huge backlash in 2004, lots of state constitutional amendments. There had been a pushback at Congress in something called the Defense of Marriage Act back in the 90s when this idea first came along. There was a whole huge effort to try to stymie this innovation, but it just kept going forward by going state to state. There was a victory in California. It was then overruled in Prop 8, but then other states, Iowa in 2009, 7-0, the Supreme Court of Iowa said you have a right to marriage equality. And so then things just started to accelerate. And by 2015, the U.S. Supreme Court said, you do. And by then, remarkably, there was a tiny little bit of upset about it, but people basically knew this was going to happen, and they've gotten used to it. And it's now one of the most accepted things that it's hard to imagine the court going back on. So that is an example of how states, if they didn't exist, we wouldn't get there. And state courts, one of the nice things about state courts ruling on state constitutions is you can't go to the U.S. Supreme Court on it. They can't be overruled. And so you could go to the Massachusetts Supreme Judicial Court and get Chief Justice Marshall to write this amazing opinion in 2003 that basically changed everything.
Professor Sarat, could you build on that, things happening at the state level, particularly in the area of criminal law?
So people, when they read the newspaper, tend to pay a lot of attention to what happens at the national level. And one recent example of that is the announcement of Attorney General Jeff Sessions of a new policy with respect to drug sentencing at the federal level. And that's gotten a lot of attention, a reversal of what seemed to be happening. And if you read the op-eds, you think this is really the beginning of the end of criminal justice reform in the United States. But if you look below the national level and observe what is happening in state after state, the effort in criminal justice reform is ongoing, and I think will not be in any way derailed by this apparent reversal at the federal level. Let me give you one other example. And so if you look at what's happening to incarceration rates in the United States, incarceration rates in the United States over the last 3 years have come down across the nation. And most of that is happening at the state level, where most of the criminal justice action occurs. And again, we don't pay attention, right? You grab the Times and you see Jeff Sessions. Another area in which this disjunction between what may be happening at the federal level and what is actually happening across the country is in, of course, my favorite subject, namely the death penalty in the United States. So people worry that now with Trump and Sessions in charge of the federal government will get back in the business of doing much more in the way of prosecution of death penalty cases. And this is, of course, an irony for those of us that live in Massachusetts, in particular, that the federal government would bring death penalty cases in states that do not have the death penalty, asserting a federal interest under federal statutes. But again, if you look at what's happening to the death penalty across the United States, at the state level, state after state is either getting rid of the death penalty or simply not using it. State after state is either getting rid of the death penalty or simply not using it. Or even where it is being used, it's being used much less. And can we say this together as if we were a reform congregation? Even in Texas. I think I said that alone, so let's do it again.
Even in Texas.
Okay, well, that's enough of that. Now I know what a hostile working environment means.
Again, standing up for my friend Frank.
Yeah.
Texas has been a leader in reform on issues relating to innocence. I've discussed this at various points with Barry Scheck, and he says that Texas is really out there in front of many states in terms of taking initiatives to avoid the conviction of innocent people. And I agree entirely with what Professor Sarat said about how criminal justice reform proceeds. There have been some very disturbing developments from Washington. There are, first of all, the Attorney General's comments about sentencing, which runs counter to the way that the country is still going at the local level. And also, I think perhaps most disturbing, one of his early speeches in February, mirroring the president's statements over time as a candidate, reflects his view that we are being too hard on the police as a society, specifically as it relates to violence committed by police officers, and that unduly restrains the police. And we've all seen how easy prosecutors have gone on police and a number of police killings of unarmed civilians. And again, there are a wave of actions around the states, and the action here is going to be primarily at the local level, and there's an increasing awareness at the local and the state level of a need for more rigor in these investigations and even the appointment of special prosecutors.
Thank you. If you remember nothing else from this presentation, remember the nice things he said about Texas.
It was a short part of the conversation.
Yeah, well, okay. Just to underscore the topicality of programming brought to you by the extraordinary class of 1977, Harlan, wasn't there an article, actually just in last Tuesday's New York Times, that shows again just how dynamic this issue is and how current this issue is?
Well, the article was about California and what California is doing in this context. And with my kids being here, I'll get a little more entertaining, or try to be a little more entertaining than I otherwise might be, because of the fallout of the dispute between President Trump and Arnold Schwarzenegger over The Apprentice. Arnold Schwarzenegger, who as governor was actually an extraordinary activist on issues around the environment, has become one of the most vocal critics of the new administration, and has pointed out around global warming issues that to talk about building an economy around saving coal is to talk about building a telecommunications revolution around the pager. And there's been this long, long tradition in California of extraordinary activism around the environment, and that is coupled with something extraordinary, which is that because of its extraordinary dynamism, California is now the 6th largest economy in the world. And that gives it all kinds of power. And one kind of power that it has is that to the extent that it can shape miles per hour requirements as to gasoline in cars and thereby regulate emissions, it is the force that will drive the nation. So if it sets standards that are higher than federal standards, it can get us more efficient cars, cleaner air, and less global warming. And the federal standards at the end of the Obama administration provided that by the end of 2025, that cars would be required to go to 51 miles per gallon. And the California standards require that by 2025, that a standard of 54.5 miles per gallon will be required. And yes, you guessed it, the Trump administration wants to roll back the federal standard. So if that happens, we will have a California standard in place much more exacting than that set by the federal government. And because automakers from Detroit to Japan to South Korea are going to want to be able to sell cars in California when they produce cars, that's going to be the standard that they're going to have to meet. And there was an EPA waiver issued by the now saintly President Nixon, providing that California could set fuel economy standards exceeding the federal requirements. And it's going to be up to Scott Pruitt and the Trump administration to decide whether to repeal that waiver. And if they do, there's going to be a lot of very interesting litigation about whether California can continue to drive the nation or whether this action is going to be preempted by federal law. Fortunately, consistent with what Professor Sarat said, there is a long history of a state role in this field and the state role in protecting the environment. Going back to Justice Holmes, some truly beautiful and ringing statements in his opinions about the state role in this area. I will then talk about something else that California is doing that is really fascinating. That California is working with other nations, with Canada and with Mexico, to develop voluntary treaties around carbon dioxide emissions and plans to be able to both cap carbon dioxide emissions within those jurisdictions and then trade them among jurisdictions that include themselves in these plans. And they have also been meeting with the Chinese, the California state officials, around setting up cap and trade policies. Where that goes, how cap and trade works, that's well beyond me, but it's again another fascinating area, and whether that's a bridge too far remains to be seen, but it's certainly very interesting.
Well, that I think sort of invites the obvious question, Austin and Paul. We've talked about where these battlegrounds have been over the last several years. Looking at your crystal ball, what are going to be the future battlegrounds where there's conflict between states' rights and the federal government?
Well, you know, there's obviously stuff going on right now that will just continue to intensify about immigration and sanctuary cities, and that whole area is one, I think, that it's just inevitable that there's going to be conflict. And it's one of the areas where the states are really actually kind of defying, not quite nullifying, but defying federal law in a way. And so certainly I think you can predict that to be at least one area. Another is drug policy. You know, in the Obama administration, states were allowed to legalize marijuana, even though it's still illegal under federal law. There was no enforcement in those states of the federal law. I don't know that that's likely to continue in the Trump administration. You could have a very intense conflict over that basic public policy question. Do you have other thoughts?
So I want to turn the Frank's question from a predictive question to a normative question. And again, I hope you'll join me in this. So if I say states' rights, are you in favor of states' rights? How many of you would say, yes, I'm in favor of states' rights?
Changed a few minds, right?
So I want to tell you my position on states' rights, lest you not have that information. So I'm in favor of states' rights in New York, Massachusetts, California, and maybe Texas, but not a lot. Now, why do I say that? I say that because I'm an extreme, now I'm an extreme states' rights relativist. There is nothing normatively valuable about states' rights in and of themselves. I'm in favor of states' rights and the assertion of state power when those assertions of power and rights advance an agenda of inclusion and equality. I'm opposed to states' rights when the assertion of states' rights and state power are used to restrict equality and inclusion. Maura Healey, yes. Kim Davis, no. I thought that would get a better reaction.
Let me try another.
Hold the line. You're at Amherst.
Just remember.
And I think it's really important. I think it's really important for people to think this through. Again, there's another great political scientist named E.E. Schatznyder. And Schatznyder said about the United States, the federal government and the state government, for people with political agendas, substantive political agendas, federalism provides the opportunity for forum shopping. So when we think about states' rights, I think what's important to think about is what arenas of conflict are available to advance an equality and inclusion agenda, rather than states' rights, good or bad. Harlan?
Yeah, let me try a slightly different cut at the answer to that question, which is that let's look at the underlying cases that Maura Healey in Massachusetts and Eric Schneiderman in New York and Bob Ferguson in Washington State are bringing. And I'd suggest that there is a principled way to look at this, which is that what they're doing typically, what was done in Massachusetts versus EPA, was a case by the states to vindicate federal law, the Clean Air Act. The case was brought by Massachusetts and its Attorney General and by the governors of various states as a way to vindicate federal law and protect the environment. The Muslim ban case was brought as a case brought under the federal Constitution. It was protecting federal constitutional rights. And I would prefer to view this. Certainly, I think that attorney generals have a right to be policy-driven. And Austin, that's where I agree entirely with you about the choices of cases. They're elected by the voters. They have a right to be policy-driven in the cases that they choose and not to bring and not to bring. But I think that looking at this framework of this anomaly of states as the new vindicators of federal law and federal rights, and state rights too, where there are state rights that are established that require protection, I think that that is a view of the role of the states that is fully consistent with the rule of law, and that the rule of law needs to be a central part of any agenda, particularly in this day and age. I would also like to just address Frank's question briefly about the crystal ball question, what's next. At this point, it's not a secret. The same way that the Republican AGs had a network going for those 8 years where they worked together to think about the cases they're going to bring, the Democratic AGs are talking with each other. There's more coordination than ever before. There's more of a focus on what to do. As always, the flip side of determining what's next is the question of what's next from this administration. Because what they're going to do by nature, because they're reactive and they sue, they're going to look at what the administration does and react. So it's driven, the limits of what they can do lie in the imagination of this new administration in Washington that will drive it. But with that said, there's one area that I think that everybody has to be critically attuned to, and that's global warming. We know they're going to act in this area. We know that it's critically important, and as always, the focus has to be how do we vindicate the rule of law? How do we look to state law? How do we look to federal law? How do we look to federal constitutional rights?
Just one quick comment. In the area of predicting, I think one of the things we're going to see happen more, given the likelihood that the Supreme Court is going to continue to be more and more conservative, is the question will be how far will the Supreme Court go to try to push back against progressive state initiatives under state law. We have, for example, now cases in which states are being sued for requiring people not to discriminate based on sexual orientation, under theories that violates people's freedom of religion or freedom of speech. And there are many people in the conservative legal establishment who would very much like to see a return to Lochner, to see the Supreme Court starting to cut back on business regulation, protecting business from economic regulation of the kind that, at least for the last 70 years, we've assumed is completely within the power of the states. So I think this tension is going to, in some ways, continue as institutions of the federal government become anti-federalism and start to try to nationalize by using the federal constitution to push a conservative agenda and to shut down things that the states are trying to do under their own states' law, which is, of course, basically what we have here is Harlan talking about the attorneys general enforcing federal law very aggressively, but the other issue is what states are doing under their own laws and whether or not the Supreme Court will continue to allow them to do that.
Great. I've been told that there is a group coming in here right when we finish, so we need to end on time, and I wanted to leave a little bit of time for your questions. So if you have any questions for this fabulous panel, please ask them, and I ask that you distill them, condense them, and not statements that just lilt with your voice up at the end, but real questions. So yes, right there.
As someone who has been working on criminal justice policy reform in Texas for 30 plus years, I thought I was coming to Amherst to escape some of that discussion. So I'm a little disappointed that it followed me here. But I want to, Austin, I wanted to push back just a little bit about what you were saying on criminal justice policy reform. First of all, I do think you're absolutely right that the reforms are happening at the state level, no question about that. But I don't think that it's as safe a situation as you may be suggesting.
It's a what situation?
A stable
It's
situation.
safe in this situation in terms of the direction of reform. Three reasons for that. One is that I think that the reforms are fragile and they're not nearly as impressive as they may be being presented as. There are reforms, but they're not revolutionizing. Secondly, the messaging that is happening at the federal level can influence what is happening at the state level. Over the last decade or so, there hasn't been a voice pushing for tougher crime policies, and as that voice gets louder, it's going to be harder for the more progressive-minded voices to keep pushing on the messaging. And third, the federal government can influence what's happening at the state level, as it did in the 90s through grants and through rules that say that they're going to withdraw funding from the states if the states don't pass certain types of tougher crime laws. So anyway, I just want to qualify what you were saying to say that it's still a very worrisome situation.
So maybe say, I don't, I'm perpetually anxious, so that doesn't surprise me. And as people read the tea leaves, they read the tea leaves somewhat differently. So unlike in the earlier period, you now have a very assertive left-right coalition at both the national level and in many states on behalf of prison reform. The second thing, again, you know much better than I, that is driving a lot of this is the issue of costs and state budgets. And those are, as Marx used to say, base and superstructure, the issues of cost versus base. So it may be, you're right, that the messaging at the state level, it may be a little bit of grant making, will, destabilize this sort of fragile movement. I'm a little less worried than you seem to be about it.
Great question. Yes, you, sir.
Please predict the outcome of the travel ban litigation.
The question was, what's going to happen to the travel ban in the Supreme Court? I think it's a very tough case for the plaintiffs, actually. I think that to invalidate something which otherwise would be legal based on what a candidate said in a campaign about a motive when it's only a small subset of countries that are Muslim in this world, given the Supreme Court we have, I would think that they have a very good chance of getting it reversed. I'm not saying I think that's the right answer, but I think that's what's likely.
Anyone else?
Well, again, Paul is literally one of the premier Supreme Court litigators in the country. So
don't disagree with me, all right?
I'll just say that I try, particularly in these times, to live my life as an optimist.
Yes, over here. Bill.
So just to shift the focus a little bit on the healthcare. So one of the great engines that's Trumpian reform is to push stuff to the states, notably Medicaid, because they know darn well that Medicaid is going to be adjudicated far differently on a state level than on a federal level. To use state level budgets and state level ideas, the outcome of Medicaid is, number one, going to be very disparate between the states, and number two is going to be very restrictive in a lot of states, and they're very happy about that concept. So for a group of distinguished lawyers, how do you deal with that?
How do we fix the movement to block grant Medicaid and just let the states and then cut?
And how do we push back against
That, I think, is not a lawyer's problem. That's a political problem. You can't make a constitutional argument out of that.
Yeah, and look, Bill, I mean, there's law, and then there are movements, right? This may be an occasion for the medical profession to step up, as it is for doctors to step up, for hospitals to step up. So when Paul says it's not so much a medical, a legal issue, the issue of what people who are impacted can do on the ground will be as much of the answer to that as anything that we as two lawyers and a distinguished political scientist have to say.
This is a breakpoint issue, as again you know and it's been well published. This is a breakpoint issue, I think, for the Trump coalition. And I think, again, it's sort of like what I was saying to Michelle about criminal justice reform. The alliance of the hospitals and the AMA, and these are important alliances pushing back. And so I, myself, again, maybe being a little bit more optimistic, think that there are some substantial forces that are going to be arrayed against this move.
So, Dr. Hines, looks like you need to get after that, and if you report back in 5 years, let us know how that worked out. Yes, Richard.
Do you feel that the legal doctrine of preemption is anything other than a kind of result-oriented approach, or does it really guide courts in this area?
So the question is whether the doctrine of preemption is result-oriented in its application. I think,
First of all, say what the doctrine of preemption is for those of us that.
It is the situation where federal laws are inconsistent with state laws. The state law has to give way. And there's many Supreme Court cases every year about whether a particular state law can still survive federal preemption under say the Food and Drug Act preempts all sorts of state regulation of food and drug stuff. And this will be a continued area of conflict as states start to do things at the state level that can be viewed as inconsistent with federal statutes and policies. Whether the Supreme Court is more result-oriented in those cases than any other, I don't particularly see. Actually, I think that there are times when they try to follow the law very close. Other times you might criticize them as being more policy focused, but it doesn't seem to me a particularly bad candidate for sort of suggesting the court has somehow gone worse there than other places.
And it's a very complicated doctrine. It's based on we're talking about states' rights. It's a fundamental principle of the supremacy clause, and the federal law is supreme to state law. And then there are the issues as to whether an area has been specifically preempted by federal law, or whether the field, the general area, has been preempted. So it's complex, and I think your question's a good one.
Could I just say, I want to take the particular question and broaden it a little bit, because I think it's a very hard one, and not about preemption. And I want to pick up on what Harlan said about the rule of law. So if you look at the academy writ large, if you look at what political scientists and legal scholars across the country have been writing about the rule of law since the era of legal realism, which is to say over the course of more than 100 years, I would say that the predominant view, not just the predominant view, but almost the unanimous view, is that this idea that the rule of law can be separated from politics is fictive. Now, what that means is that there are a lot of people in the academy who are now engaged in substantial revisionism. They want to rehabilitate the idea. So when Trump says about a decision, it's merely political, people now want to say, as Harlan did, remember the rule of law. And so this issue, right, it is a kind of as the worm turns, where a lot of progressive scholars say, oh, law and politics, and we can predict to a very high order of certainty how every judge on the United States Supreme Court will vote in contested cases where those contested cases have any value dimension to them. We know where they're going to end up. So to say that, well, there's no politics to law, is to engage in something which is kind of empirically very complicated. But as Harlan pointed out, very normatively important now to talk about what the values of the rule of law are. And to stand up for those values and to differentiate politics from ideology, or politics small from politics writ large. So I don't think it's just a matter of the issue of preemption, as important as that is. I think in terms of what you said, it's something that we're all going to have to now speak out about. And when your colleague at Georgetown wrote this editorial in the Washington Post about Judge Gorsuch, again, a progressive, important litigator, in defense of his nomination on the grounds of his commitment to the, quote, judicial role, that was an important moment in this turn a little bit away from all laws politics anyway.
Thank you.
That's a great way to end our panel. Let's give a round of applause to our participants.